first topic is meaning of contract. For this, we should know the meaning of offer, acceptance, agreement. Offer, when one person communicates something with an intention to obtain acceptance, that is known as offer. Acceptance, agreeing to the offer, is known as acceptance. Section number, offer, section 2, subsection A. As I told you before also, wherever possible, try to learn section numbers. Acceptance, section 2, subsection B. Next is agreement, section 2, subsection E. What is an agreement? Together, offer and acceptance is known as agreement. Every promise or set of promises. When this agreement will become contract? When agreement is enforceable by law. Contract, section number 2, subsection H. Now, there are certain agreements which can never turn into contract. What are these? Social agreements. Social agreement example. Urvashi is conducting a birthday party. Invited you, all of you. Kavya has college, phone not working. Kirtik also not going. MOB exam. So can Urvashi file a case against them? No. It is only an agreement but not enforceable by law. Clear? There is a case law which I have written, Balfour versus Balfour. Anyone remembers? Balfour versus Balfour. Anyone remembers? This case law is the husband and wife. Wife gets ill, so she asks her husband that you have to pay me monthly a certain amount. Assuming 1 lakh you have to pay. If husband does not pay, this was only orally. So understanding between both of them. Husband paid for 3 months. From 4th month onwards, he did not pay. So can wife file a case against husband? No. Wife cannot file a case against husband. So this was a social agreement. It was not a contract. Clear? Next is what? Essentials of a valid contract. Now this topic is covered under section 10. In this also there are 2 parts. There are certain elements which are not covered under section 10 and certain elements are covered under section 10. If you see, as given by section 10, not given by section 10. As given by section 10, if you see all the units, there has to be a proper offer and acceptance. There has to be a consideration, lawful object, free consent. Then what you have next topic? It has to be legally possible to perform, impossible, going to moon, taking stars. All these are impossible. So all that is not allowed. That is covered under section 10. Apart from this, there are certain elements which are not covered, not given under section 10. What are they? First one is there has to be 2 parties. 2 parties. Who can be 2 parties? It can be any 2 individuals. 1 individual, 1 corporate, 2 corporates. So it can be 2 natural persons or 2 artificial persons. Second one is there has to be an intention to create legal relationship. So what do you mean by legal relationship? If any of the parties do not fulfill the terms, then the other party should be able to go to the court of law. That is only intention to create legal relationship. Third one, recording. Third one is the terms of the contract have to be certain, definite, and not vague. Best example? The terms of the contract have to be certain. Example: oil. Okay, 10 liters of oil. The question is which oil? Clear? Next, it is to be possible to perform, possibility of performance. Then one more is there, fulfillment of legal formalities. Now, for example, there are two friends, A and B. A is having a land. He is going to give it to, or B is going to buy it from A. You take the documents, you take the papers. Is the ownership transferred? No. Why? Take the papers, take the land, take the keys, if it is a house. Is the ownership transferred? Why? Legally. The property has to be registered. So registration is a legal formality. It has to be registered in the name of B. Clear? These were the terms which are not covered under section 10. Covered under section 10, we will see each one in detail. Next heading is types of contract. Okay, 2 minutes I give you the first page. Just go through the first picture image. If you have any doubts, you can ask. Something is not understandable also, you can ask. In your notebook, there is one difference. Just write down difference between agreement and contract. Next is types of contract based on validity. So there are 5 types of contracts based on validity. First one, valid contract, void contract, voidable, illegal, unenforceable. 5 based on validity. I repeat, valid, void, voidable, illegal, unenforceable. Now, valid contracts are what? Which has covered all the essential elements given under section 10. It is a valid contract. Void contract, void contract. So initially when the contract was made, it was valid, but subsequently it became invalid. That is void. How? For example, A and B. A agrees to deliver 100 kg of sugar to B. A is having a factory on what date? 10th December. But on 7th December, there is a fire which took place in the factory of A. Will A be able to deliver the 100 kg of sugar? No. So initially the contract was valid. So only we use the term void contract. Initially it was valid, but subsequent occurrence, it became invalid or void. Clear? Had it been void from the beginning, example, contract entered by minor. Can a minor enter into contract? No. So if he enters into contract, the term to be used is void agreement. Clear? So there is always a difference when to use void contract, void agreement. Void contract is initially it is valid, then it becomes invalid. Void agreement is from day one it is invalid, void ab initio. Clear? Best example, minor's contract. Next, third one is Voidable contract. Voidable. The term voidable is used where? You remember which contracts the term voidable is used? Which unit? All contracts voidable, voidable, voidable. Undue influence, coercion, undue influence, fraud, misrepresentation. In all these cases, the contract becomes voidable. Now, voidable means what? At the option of one party can avoid the contract, or he may continue the contract. For example, in case of undue influence, doctor and patient, a doctor may advise to the patient that you will have to undergo the operation. There is an option available to the patient that he may enter into contract, he may not enter into contract. Wherever this option is available at the option of one party, it is termed as voidable. Clear? So majorly wherever free consent is not there, it is voidable. Next, illegal agreements. So if you see, illegal is attached with the word agreement. Illegal is never a contract. Illegal are always agreement only. Illegal agreement means which is not allowed by law. Example, driving without helmet, murder. Clear? So what is the effect of illegal agreements? They are all punishable by law. Last one, fifth one is unenforceable contract. What do you mean by unenforceable contract? All the terms and conditions are valid, except that there is some problem in technicalities. For example, name of the parties may not be right, or the location or the place or the age, some information given might be wrong. That is called unenforceable contract. Clear? All the five under basis of validity: valid, void, voidable, illegal, unenforceable. Next, on the basis of formation, there are three contracts on the basis of formation. Four contracts. Okay. First one, express. Second one, implied. Third one, quasi. Fourth one, e-contracts. Express contracts, either orally or in writing, by words. It is termed as express contract. Implied contract, the term used is by conduct of parties. Clear? For example, you go to an ATM machine. Do you talk with ATM machine? No. But you know what to do to withdraw the money. So there are no words used in case of implied contracts. Another example, standing near the bus stop or getting inside the bus. Automatically when you get inside the bus, you will have to buy a ticket. There is no agreement pre-made between the conductor and yourself. Here, implied contracts, another term used is, remember, tacit contracts. Implied contracts, another term used is tacit contract. Clear? So the meaning of tacit is silence. There is no words used in case of implied contracts. Third one is quasi contracts. So in quasi contract also, there are no agreements pre-made. There are 5 specific quasi contracts given in Indian Contract Act. A specific unit is there. I will give you one example of finder of lost goods. In finder of lost goods, the example, when you're walking on the road, you find a purse fallen, you pick it up. What, if possible, you will find out whose it is and you will try to hand over. Otherwise, you'll go to the police station and hand over. Was there an agreement? Were you responsible to find out? No. So this is an example of quasi-contract. There is no agreement pre-made. Just by operation of law, it arises. Fourth one, e-contracts. E-contracts are nothing but electronic contracts. Contracts made by electronic mode. Next, based on performance. Based on performance, there are 2. Executed contract, executory contract. Executed means what? Always there are 2 parties in the contract. Both the parties must have performed their obligation. Executed. A sells 100 kg of sugar to B, has sold. B has to pay for this, has paid. Both of them, the obligations are done. Executory. A has delivered sugar, but B still has to pay. 1 week credit period is given. So he has to pay. He will pay within 1 week. Unilateral executory contract, one party has done, one party still has to do. Bilateral, both the parties still have to. Here, any doubts? Go through the second page. Now I've sent certain images in the group. See that second page. This is only a revision, okay? This book, you cannot, you people are, if we studied this, it is enough. Amin will ask that, didn't come today. No? What is his name? No. Venkat Shastri. Fully you should read, okay? Just like revision, that's all. Done? Next heading is offer. How many people are there in offer? There are two. Offerer, offeree. Types of offer. 5 offers are there. First one, general offer. General offer means offer which is made to public at large, to a large group of people. Who can accept the offer? Anyone can accept the offer. Is there any case law? Yes, Carlyle versus Carbolic Smoke Ball. What happened in this case is, this particular company told that if you take this medicine, you will not have influenza or you will not fall sick. But this particular lady took it and she fell sick. So she claimed that you only told I will not fall sick, so you will have to give me compensation. Clear? So it was a general offer and anybody can accept this offer. Second type of offer is specific offer or special offer. Now in specific offer, the offer is directed towards a particular person. Who has to accept this offer? That particular person only has to accept this offer. Example, A, B. So contract is between two specific people. Third one, cross offer. Cross offer is when there are two people, A and B. A is owning a car. A offers B that I want to sell my car for 5 lakhs. B tells I want to purchase your car for 5 lakhs. Does this cross offer means acceptance by B? No. After B makes an offer of 5 lakhs, A can rethink. Oh, he himself is asking for 5 lakhs. That means I can quote even more. 5,50,000 I will quote and I will find some other party. Clear? B cannot tell that you are ready to sell your car. No, now why are you not giving? So these are only cross offers. Cross offers does not involve acceptance. Two identical offers made, it does not result into a valid contract. Fourth one is counter offer. counter offer. Same example, A wants to sell his car for 5 lakhs. B tells that I am ready to purchase your car, but not at 5 lakhs, at 4,50,000. Acceptance is whatever terms and conditions are given of the offer, it has to be accepted in the same way. There cannot be any changes made and then accepted. Will it be valid? No. So in case of this, he has made a change, he has negotiated 50,000 and thereafter he is telling that I'm willing to buy your car. Is this a valid acceptance? No, it is a counter offer or a qualified acceptance, conditional acceptance. Fifth one is standing or continuing offer. Now what is the standing or continuing offer is? If offer is announced and a particular time period is given, supposing 10 days time is given for acceptance, that is called standing offer. Example, examination date opened. An offer is given to all the students that you will have to register. Time period is given 10 to 15 days. If you register, you have accepted. Clear? So this is an example of standing offer. Next is essentials of a valid offer. So what are the requirements to be a valid offer? First one, it must be capable of creating legal relationship. We saw already social agreements are not valid. It has to be possible to go to the court of law. Second one, the terms of the offer must be certain, definite and not vague. Clarity has to be there. Clear. The best example is oil example. Third one, if at all they ask you essentials of a valid offer, you will have to state the statement as well as give example. Wherever possible, give examples. Third one, it must be communicated to the offeree. There is a case law here. Lalman Shukla versus Gauri Dutt. Anybody remembers? So there was a person whose nephew was missing. And then this person called his servant, asked him that please go and search wherever he is, please bring. After this person left, after this servant left, he gave an advertisement in the newspaper that anybody who finds my nephew will be rewarded. Will be rewarded. Does this servant know about this ad? No, he doesn't know. He doesn't know about the advertisement. But finally, the servant only got back the nephew. Then his friends told that you will be awarded now. You will be rewarded. He has given you a prize money. When the servant went and asked that where is my prize money, I brought the nephew. Lalman Shukla told that you didn't even know. Then how can you claim? Understood? Clear? You should be informed before, you should be communicated before, only then you can claim. It has to be communicated to the offeree. Next one. Must be made with a view to obtain the assent of the other party. Why do we make an offer? We have some hope that the other party will accept it. Next, it may be conditional. The terms of the offer, you can put conditions. It has to be in the prescribed mode. If the payment has to be made by way of cash or by way of check or by way of net banking, all the conditions you can put in the offer. Whatever conditions you have put, the acceptance has to be in the same way. You cannot change the conditions of the offer and then accept. Then that will not be a valid acceptance. Clear? Offer should not contain a term, the non-compliance of which would amount to acceptance. Now, supposing there is a contract between A and B. A is buying a car from B. He tells that I will pay you 5 lakhs to buy the car. If you don't reply in 3 days, I will assume that I am the owner of the car. I will send you the money. B did not reply. Can A assume that I will buy the car and send money? No. No. Clear? So if a term is there and the B has not complied with, it does not amount to valid offer. Acceptance also has to be communicated. We will see in acceptance. Yes. Difference between offer and invitation to offer. Difference between offer and invitation to offer. Now, invitation to offer. Example.
Price food is kept outside the shop.
Yes.
The person came and asked
Boards, sale, flat 50% off. Clear? A customer comes in and purchases. By mistake, that board was kept. 2 days before itself, the sale got closed. The customer comes and tells that the worth of the dress was 1000 rupees. You will have to give me at 500. The customer is making an offer. It is on the shopkeeper to accept it or not to accept it. He can say that the sale has got over, by mistake we kept it. The keeping of board of flat 50% is not an offer. The customer who is going to the shop and telling the shopkeeper that I have to buy this dress, you have to give me flat 50% off, that is offer. Understood? So, statement of invitation to offer is before offer. It is not offer. Other examples are initial public offer, IPO. IPO advertisement given in the newspaper, it is not offer. Anybody who purchases the shares, not necessary that they will get the allotment of shares. The customers who are applying for the shares, they are making offer to the company. It is on the company to allot them shares or not to allot them shares. If any person does not receive the allotment, he cannot file the case that I applied for the shares, you only didn't give me the shares. No. Understood? Next, at the hotel, if you go, the menu card kept. Menu card kept does not mean you have to sit and eat all the things. You make an offer to the hotelier that I am ready to eat these 3 items. It is on the hotelier to accept it. Sometimes he may deny that we don't have this particular. Understood? Clear? The difference between offer and invitation to offer? 2 minutes I give you, just go through. There is a case law also here. Harvey versus Fassi. Yes. In this, what happens? One particular person makes an offer telling that, will you sell us bumper hall pen and at what price? Supposing this Mr. A has asked, will you be able to sell us and at what price? B just quoted the price. We will be able to sell you at rupees 200. He never answered the first question, yes, I will sell you. He did not answer that. He just quoted the price. Quotation of price is not a acceptance. It is just an offer. Understood? Clear? Finished? Next is rules of valid acceptance. First rule is acceptance must be given by the person to whom the offer is made. In case of specific offer, that particular person. In case of general offer, any person. Second one, acceptance cannot be conditional or qualified. It has to be absolute and unqualified. So you cannot attach terms and conditions and then tell, okay, I am ready to accept. You make these modifications. That is not a valid acceptance. Third one, acceptance must be communicated. So the person who wants to accept the offer, he cannot write a letter and keep it in his cupboard. He has to post it to the other person also. He cannot think in his mind that, okay, I'm ready to buy. He has to write an email also. Clear? Only then acceptance is valid. Next, mere silence is not acceptance. So there is one important case law here, Feldhaus versus Bindley. Now what happens in this cases? Anybody remembers? There were two people, A, B, okay, one uncle and one nephew. A, B. B is having horses. A tells to B that one particular horse, supposing name X, this horse I am ready to buy. B was auctioning all the horses. He appointed an auctioneer. He gave all the horses to auctioneer and informed him and informed the auctioneer that this particular X horse do not auction. Clear? Do not auction. Why? Because B was thinking that I have to give it to my uncle A. Did B inform A? He did not reply. He did not reply, okay, I will give you my horse X. But he informed the auctioneer that please do not auction this particular horse X. Now what this auctioneer did is, he auctioned all the horses. He auctioned all the horses including X. Can A come and file a case against B? No. Why? Acceptance was not communicated. Clear? He was willing, he was agreeing, but he did not inform to. So this case cannot be filed. Understood? Case law name Feldhaus versus Bindley. There cannot be an implied acceptance. Next, acceptance by conduct. Now this, in the same case, in this acceptance by conduct, when A asks B for this particular horse X, next day itself, he placed the horse in A's house or A's place. It is a implied acceptance. Okay, this fellow asked for this much money. I will go and hand it over. Clear? Acceptance must be in a prescribed mode and within the time specified. If the time specified is 5 days, acceptance has to be made within 5 days. Your examination portal is open for 15 days. Can you make the application on 16th day? No, closed. Same day. It has to be made within time prescribed. The last heading is communication. Communication of offer and communication of acceptance. When is offer communicated? I'll give you one example. Supposing A wants to buy the car of B for 5 lakhs. He has made the offer on 7th December. He has written a letter. Okay. It reaches B on 8th December. This offer, when it is communicated 8th December, on what basis you are telling? It reached B. It has been communicated. It has come to the knowledge of the offeree. What if he did not open the letter on 8th? He opened the letter on 9th. Then 9th. Then 9th. It has to come to the knowledge of the offeree. Then only it is a then the offer is communicated. Next is communication of acceptance. Communication of acceptance. Now in this there are two parts. The same example. A writes a letter on 7th December. It reaches B and it comes to the knowledge of B on 8th December. Now he has to reply. He is also interested to buy the car. Okay. He again writes the letter on 10th December and puts it on post. It reaches A on 13th December. It reaches A on 13th December. According to A is offerer, proposer. According to A, when is the acceptance complete? 13th December. According to A, acceptance is complete on 13th December. See, according to A, this fellow has written it on 10th and he is putting on post by 10th. So according to A, it is considered to be accepted by 10th December. According to B, it will be considered as accepted on 13th December. Clear? B accepts the offer. Now he wants to communicate it. Letter writing. He has written the letter on 10th and gives it to post on 10th. So as per A, acceptance is done on 10th. As per B, acceptance is done on 13th. 13th. Clear? No doubts? Yes. In this example, A is making an offer on 7th December. Clear? He writes a letter and posts it to B. It reaches B on 8th and he reads the letter on 8th itself. See, offer is being communicated because it comes to the knowledge of the offeree. When you got to know, that means you understood the terms of the offer. Now your option is whether to accept it or not to accept it. B decides to accept it. He writes a letter on 10th and gives a post on 10th itself. So according to A, offerer, it is treated as accepted on 10th. It reaches A on 12th. According to B, offer is termed to be accepted on 13th. Sorry. Clear? Understood? Now in this there is one more topic attached. What is that? Revocation. Revocation means what? Cancellation. Now you have to tell me when the offer can be revoked. I will change the date here once. Find this better. Okay, it reaches on 9th. So when the offer can be revoked. You don't know the information. Even before you know the information, I cancel it. It will be treated as revoked. I put an advertisement. Okay. Supposing on Instagram, I put an advertisement. Even before there are any views, if I delete the post, revocation of offer, yes, sale from 20th December. But I feel that is Christmas season, why should I put a sale? I delete the offer. So even before it comes to the knowledge of the offeree, if I delete it, it is revocation of offer. So when it can happen? Before the communication of offer to the offeree. Offer can be revoked. Understood? So any time before 9th December, offer can be revoked. How, ma'am? Already it is on post. I cannot go and tear it also. How? He has to write another letter. And by way of speed post, express post. This letter reaches on 8th. This letter reaches on 8th. So revocation reaches even before the offer. It will be treated as revoked. Clear? Understood? No doubts? When will acceptance treated to be revoked? Acceptance. Now who has accepted? B has accepted. Now he has to revoke his acceptance, correct? When can he revoke his acceptance? According to him, acceptance is complete on 13th December. Even before this letter reaches on 13th, he has to post the express post. And this letter reaches on 12th. Revocation reaches even before the acceptance of acceptance. So it will be treated as revoked. Understood? Clear? Any doubts? Shastri? Awake? Yes? The last topic of this unit is modes of revocation. How we can revoke an offer. First one, by giving notice, by informing that I will not be able to proceed. Whatever offer I have made, please consider it as cancelled. Second one, by lapse of time. If it was a standing or continuing offer, after the expiry of the time period, automatically the offer is lapsed. Third one, non-fulfillment of conditions. So supposing the acceptance has to be made in the prescribed mode. If I specify it in offer itself, and if it's not in that mode, or if the payment is not in that way, it is treated as revoked. Offer is termed as revoked. By death or insanity, A has to perform the offer. If A itself is not there, then who will perform the offer? A is a singer. A has to sing in a particular show. Before the show, A is not available, A is dead. Will the offer continue? Automatically the offer is revoked. Next, counter offer. Counter offer amounts to rejection of the original offer. Counter offer is making a new offer. Original offer is revoked. Next, non-acceptance in prescribed mode, subsequent illegality. Now they are telling that the using that Tetra Pak water bottles is not health friendly, correct? Very soon, another 2 to 3 years, if they ban the bottles, not allowed, water cannot be, the mineral water cannot be served if they ban. Before the ban, 2 days before only, A has accepted the offer to deliver 1000 bottles to B. 2 days before the offer contract was valid, but after 2 days the contract becomes void, revoked. Clear? Subsequent illegality. Any doubts? 2-3 minutes I give you. You can go through from the rules of valid acceptance, communication of offer, revocation. Finished? I have sent one more picture. There is a question there. Should I read? Mr. B makes a proposal to Mr. S by post to sell his house for rupees 10 lakhs and posted the letter on 10th April. The letter reaches to Mr. S on 12th April. He reads the letter by 13th April. Mr. S sends his letter of acceptance on 16th April and the letter reaches Mr. B on 20th April. On 17th April, S changed his mind and sends a telegram withdrawing his acceptance. Telegram reaches to Mr. B on 19th April. Examine with reference to Contract Act on which date the offer made by Mr. B will be complete. Discuss the validity of acceptance. What would be the validity of acceptance if letter of revocation and letter of acceptance reached together? On which date offer made by B will be complete? Thirteenth. Shastri? 15th. Others, any doubts when the offer is set to be completed? The communication of offer is set to be completed on 13th April. Why 13th April? Because it came to Mr. S and he read it. Clear? Next, discuss the validity of acceptance. Acceptance was made on, according to B, 16th. According to S, 20th. Clear? But the acceptance was revoked. Revocation, the telegram reached on 19th and revocation is valid or not valid? Valid. Valid. Clear? What would be the validity of acceptance if letter of revocation and letter of acceptance reached together? Whichever B reads first. If he reads acceptance first, then acceptance. If he reads revocation first, then revocation. Clear? Next is, shall we continue? Unit 2, consideration. Consideration is?
What benefit the one is taking from that?
So something in return. What I give and what I get back. That is called consideration. Another term used is quid pro quo. Rules regarding valid consideration. First one, consideration must move at the desire of the promisor. If the offerer has asked something, the offeree has to give, or the acceptor has to give that only. If he has asked for money, he has to give that. If he has asked for gold, that only has to be given as consideration. Clear? So it has to move at the desire of promisor. There is a case law here, Durga Prasad versus Baldio. What is this case law is? Yes. Now in this case law, what happens? There is a village. Okay. In that village, there is Mr. A and there is Mr. B. He informs to B that all the villagers are going outside our village to sell the articles. Whatever things they have, they are going outside places and selling the articles. What we will do is, I will give you money. What you do, you construct within our village marketplaces. You construct marketplaces. So B is a contractor. He constructed the marketplaces so that villagers can hire these spaces and sell out their articles. Now villager C came and took the place on rent. This, what he's telling that, apart from rent, you have to give me a commission on sale price also. What he's telling, apart from rent, you have to give me commission on sale price also. C told that I am going to hire this place and I have agreed for rent only. I never agreed for commission. Why should I give you? Clear? Why should I give you? So this fellow made a offer to purchase this place for rent. This rent only I will give you. I will not give you commission. Clear? This collector cannot ask for commission. So it has to move at the desire of promisor. Which case law? Durga Prasad versus Baldio. Next one. Consideration may move from promisee or any other person. There is again one case law here. What is the case law's name? Chinnaya versus Ramaya. What happens in this case? Chinnaya versus Ramaya. There is a mother, there is a daughter, and there is a brother. Correct? This brother is this mother's brother. Daughter and mother fights. Daughter tells that whatever assets you have, you transfer to my name. All the assets you transfer to my name. Mother tells that okay, you take all the assets, but what you should do is you should give monthly 1 lakh to my brother. Monthly 1 lakh to my brother. Daughter says okay, I will give. She accepts it. Mother dies. This daughter, after that, she is telling that I will not give you 1 lakh. Brother files a case. Why daughter tells I will not give you 1 lakh is, she tells to brother that you are not giving me anything. Why should I give you 1 lakh? Why should I give you 1 lakh? Court told that consideration may move from promisee or any other person. You have already received all the assets from mother. That is a sufficient consideration to pay 1 lakh per month to brother. Clear? Any doubts? Next. Case law name was Chinnaya versus Ramaya. Next is executed and executory consideration. So consideration can be past, present or future. Now I have given, Mr. A has given a loan of 1 lakh to B. This loan continues for 5 years. And for 5 years, B has to give interest. As agreed, B has to give interest. Can B tell that I gave for 2 years, 3rd year I won't give? No. Loan is still there, no? So he will have to give interest. Clear? Another example is credit period. A sells 100 kg of sugar to B and B tells that I want 2 months credit period. Sale of 100 kg of sugar is past consideration for B and payment for this 100 kg of sugar is future consideration for A. Clear? So consideration can be past, present or future. Exchanging immediately is present. Understood? Next one, need not be adequate. There has to be some consideration. Consideration need not be adequate. Sale of 100 kg of sugar in the market per kg of sugar is 100 rupees. So the total prize money I should get is 10,000. But he is giving it at 20 rupees. Why so less, ma'am? Brother. So okay, take discounted price. 20 rupees he is giving. Is it adequate? No. It is not equal to market price. No problem. It is equal to the cost price. It is sufficient. So consideration need not be adequate, but there has to be some consideration. Next, performance of what one is legally bound to perform. Legally, you have done some work, you can claim compensation, you can claim consideration. Over and above that, 10,000 rupees sugar I purchased, I will give you 10,000 rupees only. Over and above that, if you ask me for 1 gram of gold also, will it be valid? Clear? Consideration should be real, not illusionary, not unlawful, immoral, opposed to public policy. So consideration has to be legal. Consideration has to be real. Example of unreal consideration. I have a rocket. I will take you for a ride to Mars. He wants to go to Mars. Is it valid? Will you accept? That is only not real, illusionary.
If he signs a contract with Elon Musk.
With
He signs a contract with Elon Musk.
Elon Musk. Elon Musk is having rocket? I don't know. He is not a scientist as far as I know. 2 minutes, I give you just revise the rules of consideration. Done? Only 3 topics are there in this unit. Second topic is suit by a third party. So can a third party to a contract file a case? The contract is between A and B. Can C file a case? No. No. The terms and conditions have been discussed between A and B. If A doesn't fulfill, B can file a case against A. B doesn't fulfill, A can file a case against B. But can C come and file? No. But there are few exceptions. First exception is trust. What is this trust? I trust you, you trust me. Trust? No. What is trust? School. Okay, ABC school is there. There was a particular donor. This donor has given the land. There were some 5 people who were willing to construct a school and run the school. So the original agreement was, or the contract was between the donor and trustees. Correct? Who are the beneficiaries of this trust? Students, parents and students of the school. These are the beneficiaries. If any term which the trustees of the school have informed to the parents, if they do not fulfill, can the parents and the students file the case against the trustees? Yes. The beneficiary is a third party. He can file the case against the trustees. Clear? Second one, family settlement. Family settlement is HUF, Hindu Undivided Family. Okay. Now in Hindu Undivided Family, a child, once he is born, he becomes a member of that family business. This family business was divided among the members of the family. But the youngest member tells that I did not get any share. When the partition took place, he was born, but he was very young, 2 years old. He can grow up and file a case against this HUF telling that the partition was not proper. I did not get my share. Clear? Third one, marriage contracts. Now, marriage contract is, supposing there is a girl and a boy, A and B. In this contract, what happens? So this is a proper arranged match. A's father, she is a girl, and B's father. The girl's father informs the boy's father that, okay, I will get A married to B, but you have to pay my daughter monthly 30,000. You have to pay my daughter monthly 30. Ulta trend. Okay. You have to pay my daughter monthly 30,000. B's father agrees. Okay, I will pay. After marriage in 10 days, A's father died. A's father died. The original contract was between A's father and B's father. There was no contract between A and B. People are getting married. Or there was no contract between the daughter-in-law and father-in-law. But daughter-in-law can file a case against father-in-law telling that you did not give me 30,000 per month. The contract is invalid. The marriage is invalid. I am going. This is only marriage contract. Next is contract by agent. Now, what is the agent? What does the agent do? There is a principal and there is an agent. There is a principal and there is an agent. Whatever instructions principal give, the agent has to follow. And on the basis of that only, agent enters into contract. Clear? The contract was between the agent and an outsider, but principal being the superior person to an agent, he can also file a case against this third party. Last one, assignment of contract. In case of this assignment, assignee. Now see this example. Mr. Ankit Sharma has assigned his insurance policy to his son. Assigned means I have given the benefits of this policy to my son. Rights and liabilities relating to this policy to my son. Now, son can claim even if he was not the party to the contract. So, the original contract was between the insurance policy holder and the insurance company. What the policy holder father has done, whatever benefits and whatever liabilities of premium is there, I am giving it to my son. I am aged. I cannot continue with the obligation. So, the son will take over, and on maturity, the policy amount will be received by son. Both rights and liabilities are transferred to in case of assignment. Any doubts? With this information, can you form a 5-mark answer and write? Yes? Sufficient, no? Last topic for this unit. So we saw that one of the essential element to be a valid contract should be consideration. Without consideration, there is no contract. No consideration, no contract. But there are few contracts where without consideration also it is valid. Okay. First one, there has to be natural love and affection. If there is natural love and affection and a contract is made between those parties, there are few terms attached. What is that? It has to be in writing. Orally you make and come and file a suit and fight in the court. Not possible, go home. It has to be in writing. It has to be registered. It has to be registered. The agreement must be between parties who are related to each other. There has to be some sort of relationship. And the agreement must be out of natural love and affection. So 4 conditions: it must be in writing, it must be registered, out of natural love and affection, and between related parties. Only then, even if it is without consideration, it is valid. Case law. Here only that case law also will come. No? Balfour versus Balfour. Because it was oral, she could not go to the court of. Second one, compensation for past voluntary services. In the past, There was a doctor, Mr. A, and there was a patient, Mr. B. Both were friends. Okay. 2 years before, A has operated B, saved his life. At that time, this friend or the patient did not have money. He became all right. He started working. In 1 year itself, he earned a lot. What he did, he repaid back whatever doctor fees was there to the doctor friend. When he is repaying back, did he receive any service? No. It is a compensation for past voluntary service. That time doctor has rendered service without expecting any consideration because he knew that patient did not have sufficient money. Clear? Third one, promise to pay time barred debt. Now what is this time barred debt? I already told you that there is an act, limitation act. Supposing A has to pay B 50,000. Clear? B has to give a reminder every month that you have to pay me 50,000, 50,000, 50,000. If for 3 years B forgets, okay, 50,000 will leave. That amount after 3 years he cannot ask. He cannot go to the court of law and ask that this fellow did not pay me. What is the time period under Limitation Act? It is 3 years. If you have continuously given notice, then it's okay. Even if he doesn't pay, you can go to the court of law. If you have not given notice, you yourself forgot. In the 4th year, you get up and think that, okay, that money has to come. You cannot go to the court of. But A, honest person, in the 4th year, he comes and pays 50,000. Clear? He cannot tell B that you did not give me anything, I'm giving you 50,000. No. Already 3 years back, he gave money. No. For that, it is sufficient consideration. Promise to pay time barred debt. Next, to create agency. To appoint an agent, we need not give him fees or we need not give him salary. You do work, you will get your commission. Completed gift. In case of gift, do you receive back any consideration? No. Do you expect anything? Bailment. There are 2 types of bailment. Gratuitous bailment, non-gratuitous bailment. In case of gratuitous bailment, there is no consideration, but it is a valid agreement. Charity. You give charity without expecting anything in return. So all these are agreements without consideration and valid. I'll give you 5 minutes. Just go through the last 2 topics. Finished? See, the same question only is there, but it's okay, you read from there. Sohan Lal. Who will read? Tamin, read now. Sohan Lal sold. Read.
Mr. Sohan Lal sold 10 acres of his agricultural land to Mr. Mohan on 20th September 2020 for 25 lakhs. The property papers mention a condition, other details, that whosoever purchased the land is free to use 9 acres as per his choice, but the remaining 1 acre has to be allowed to be used by Mr. Chote, son of the for carrying out farming or other activity of his choice. On 12th October 2020, Mr. Sohan Lal died, leaving behind his son and wife. On 15th October 2020, purchase started construction of an auditorium on the whole 10 acres of land and denied any land use. Now Mr. Chote Lal wants to file a case against the purchaser and get a settlement above in light of provision of Indian government and decide upon Mr. Chote Lal's.
Have you seen this question before? Where? How many of you have seen this question before? Shastri, did you see this question?
Somewhat.
Somewhat.
Sort of.
Okay. Which case law does it resemble? It is Chinmaya or Chinnaya? Chinnaya. Chinnaya versus Ramaya. It is a book back question, ICA module question. Clear? Will Chote Lal win the case? Yes. What is the point to be written? Consideration may. You have to write exactly, only then you will get marks. Consideration may move from Promley or any other person. Chinnaya versus Ramya, please quote the next. Finished going through? 5 minutes. When I will finish, you know how much is there. Next is Unit 3. 1 and 2 done. Unit 3. With this speed only, the day before exam is there, no? But you have so much time, no? This time? 3 days. 3 days time. Full law you can study. All past year questions also you can complete. So much time is there. For law especially. That time only question paper will be difficult. Law always like that only difficult only, I feel. Okay. Now in this unit, Unit 3, other essential elements, the first topic is capacity to contract. Who can enter into a valid contract? Where it is given section 11. Major, sound mind, not disqualified. Major, what is the age? 21 or 18? 18. Who has completed 18 and above. Clear? Now we will see the contract or minor's agreement, not contract. So if a minor enters into an agreement, what will happen? Rules governing minors, change that. No, it is not contract. Sorry, I wrote contract. Agreement. First one, it is void ab initio. From day one, it is void ab initio. What is the case law? Mahari Bibi versus Dharmadas Ghose. What happened in this case law? Loan. A minor took a loan. Is he liable to repay? No. He will not be liable to repay. Second one, no ratification. Ratification means validity. Clear? Same example will continue. A loan taken while he was 15 years of age. Very soon he turned 18. After turning 18, the provider of loan, the giver of loan cannot come and claim that you took a loan when you were 15, now give me back the money. Can he claim? It doesn't automatically become valid after he turns major. Clear? Third one, he can be beneficiary. He can be beneficiary. That means he can receive money. He can be given a bill in his name. He can be given a check in his name. But he cannot be held liable. He can be a beneficiary to a contract. He can be admitted to the benefits of partnership. Partnership also, profit means I will come. Loss means I will come. Clear? Next, he can always plead minority. You can always tell that I am a minor, I am not liable. It is your mistake. You didn't ask me my age also. You gave me money. Your mistake. Just don't go by the size. Clear? His estate is liable for necessaries. This is an important topic. Sometimes we forget. We always think that minor is not liable, not liable, not liable. But for necessary goods, food, clothing, shelter. So if you go to a supermarket store, you cannot go there and take 2 biscuit packet, 2 chocolate, 2 chips packet, 1 Maaza, everything and go out. Telling that I am a minor. Valid? No. Even on lollipop also 5 rupees we have to give. Yes. So from where he will give? Whatever estate or whatever property he is having, from that he has to. Next. Enter into contract by guardian. So a contract entered into by a guardian on behalf of a minor. If it is only for the benefits of minor, it is valid. If a contract is making a minor liable, it is not valid. No insolvency. Can minor be declared insolvent? Never. He doesn't have anything what he'll be declared insolvent. Can be agent. A minor can be appointed as an agent. Any type of agency will not hold him liable. Only such type of agency he can take up. Partnership, we know this. Cannot bind parent or guardian. So a minor's act cannot bind his parent or guardian. Minor taken a loan. The loan provider cannot go and ask the parent, your child has taken loan, 50,000. What will parent tell? Who asked you to give? I didn't write. Surety. Surety means what? A person who is giving a guarantee. For a minor, there can be a surety. If a minor does not pay, automatically the surety has to pay. Because he has taken up that responsibility that I will be the surety. I will be the guarantor. Minor, can he be a shareholder? Never. He cannot be a shareholder. Liability for tort. Tort means what? Some type of mistake, some type of wrongful act, that is called tort. Will minor be held liable for torts? No. You go and hit someone with one stick. Urvashi is going to go and hit someone with stick.
She's major.
Assuming she's a minor. Urvashi escape and come. I am a minor, I am not liable. Any wrongful act you do, you will be liable. She's shaking her head. No, not liable. Okay? Clear? Okay, now we will try this. Now we saw some points, no? Try to recollect. Possible? There are some 10 points are there. But there won't be a question as to discuss position of minors agreement. There can be a case law based on a particular point, and then they will ask you to give a conclusion. So something like that, I think you'll be able to answer. No? The two important points are liability for necessaries and liability for torts. And minor cannot bind parent and guardian. Next is section 12. Sound mind. A person with a sound mind, but from past 2 days he is having a fever of 105 degrees, not in his senses. Any contract entered into by him, will it be valid? No. So usually of sound mind, but whenever he is unsound, it is usually of unsound mind. He enters into a contract when he is of sound mind. Is it valid? The term sound has to be there whenever a contract is. Third one, not disqualified. Not disqualified. Who and all are disqualified people? Alien enemy. Who is an alien enemy? The two countries which are at war. Now, what two countries are fighting with each other?
Canada, India.
Canada, India is fighting.
Pakistan.
Huh?
Pakistan.
Russia, Ukraine. So these two countries, if any person from Russia enters into a contract with Ukraine, it is invalid. Insolvent. An insolvent person cannot enter into a contract. Convict. Who is a convict? Who is a convict? Tell, you know it. Tell. Try. Convict. English word. You have been convicted.
Found guilty.
Found guilty. Only a case is going on. He is not a convict. A conclusion is done. A judgment is passed that he has to be imprisoned. He has to be sentenced to death. That person is a convict. Clear? Sitting in jail is not a convict. Just because a case is going on, he is in jail now. After the result only, he will be turning as convict. Foreign souvenirs and ambassadors. So, a contract entered into by disqualified person is not valid. Next heading is free consent. What do you mean by free consent? Huh? A person should willingly enter into contract. That is known as free consent. He should not forcefully be entering into contract. Free consensus means two people having same thoughts relating to the terms and conditions of the contract. I'll give you one example. A is wanting to sell his car, but he's having two cars. One is which car? Swift. Another is Land Cruiser. To B. Amount he's telling 10 lakhs. B thinks about Land Cruiser because Swift we will originally get for 10 lakhs. Why will I buy Swift? He thinks about Land Cruiser. But A is trying to sell Swift because it is only 1 month old. Clear? So there is no consensus at idem. Both the people are not thinking about the same thing. Clear? Now there are some 5 situations where the consent is not free. First one, coercion. Coercion. If you don't come to class regularly, I will appoint people to kidnap you. Coercion. Clear? Which section? Section 14 now. 15. So all the acts which are covered by Indian Penal Code. What is covered under Indian Penal Code is all the acts for which punishment is there. Example, murder, kidnapping, threatening. All these are covered under Indian Penal Code. Criminal acts basically. All falls under coercion. What is the effect of coercion? Kidnapping. Valid, void, voidable. Voidable. Effect of coercion is voidable. In case of coercion contracts or any voidable contract, supposing in that kidnapping case, okay, A is a father, A's son is kidnapped by B. In this process, A has given some 20 lakhs to B to hand over his son. After he just pretended to take the money and behind the police also has come. So whatever 20 lakhs this B has taken, he has to return back. So anything which has been paid or delivered during these voidable contracts must be returned back. Any benefit you get, any money you get, money is worth you get, you will have to return back. Clear? Second one is undue influence. You can write one note also. Threat to commit suicide. Threat to commit suicide is also forbidden by Indian Penal Code. So comes under coercion. Threat to commit suicide. Next is undue influence. What do you mean by undue influence? Huh? Okay, so two parties, A and B, where one person is in a dominating position to other and he is able to influence the decision or controls the decision of the other person and take advantage of that. Then there is undue influence. Just being in a dominating position and no taking advantage, there is no undue influence. Clear? So two people, one of them is in a dominating position on the other and takes advantage from that contract, there is undue influence. Example, doctor, patient. Any other examples? Teacher, student. Clear? What is the effect of this undue influence? The contract is voidable. Now, when they ask only about undue influence, you're supposed to write the meaning and these you have to write separately again. Essential ingredients. Relation between parties, position to dominate the will, mental distress, unconscionable bargain. The object must be to take undue advantage and the burden of proof. Who will have to prove that there is an undue influence? In the example of doctor and patient, doctor is in a dominating position and influencing the patient to give 5 lakhs for a particular operation. Okay. Now it is at the option of the patient to give or not give. Who will have to prove that there is an undue influence? Who will have to file a case that there was an undue influence, so only I paid and now I want back the money? Patient. Who is the victim? That person only has to file the case. He has to prove. Next is fraud. Fraud means suggesting something which is not true, informing something which is not true, or hiding some information. Hiding some information. So fraud is informing something which is not true or hiding some information. there is one topic here. Whether silence is fraud or not. Mere silence is not fraud. Just because I'm keeping quiet doesn't mean that I'm doing fraud. But where there is a duty to speak, the term used is where there is duty to speak, then it becomes fraud. This is a question actually. Mere silence is not fraud. Except in two situations, duty to speak and silence is equivalent to speech. What you have to write, ma'am? Everything you have to write. Example also, one example also you're supposed to quote. Fourth topic, misrepresentation. Misrepresentation means you yourself don't know that the information what you're telling is not true. You think that, I'll give you an example. I think or I got some news that tomorrow there is a cyclone. There is another cyclone coming by. Huh? Some cyclone.
70% chances it can be created to cyclone, or else it will move towards total run outside.
Not Chennai.
We'll invite Tamil Nadu.
No need, ma. Okay.
24 hours from now.
24 hours from now. Okay. So this information is actually not true, but we are thinking it to be true. Misrepresentation. What is the effect? Contract is voidable. There are two differences: coercion and undue influence, fraud and misrepresentation. The last topic is mistake. There are two types of mistake. Mistake of fact, mistake of law. If it is a mistake of fact, fact means that car example. A thinks to sell Swift and B thinks to buy Land Cruiser. So there is a mistake of fact. The terms are not clear. If it is a unilateral mistake, one person thinking about the wrong information, then the contract is unilateral mistake. One person is only thinking about the wrong information, then the contract is. Contract is valid. Contract is not voidable, valid. Clear? If both the people are under a mistake of fact, contract is void. Clear? Mistake of law. There are two laws: Indian law, foreign law. In case of Indian law, I have written valid, it's wrong. Cut that. Indian law, you cannot claim excuse that I did not know to wear a helmet while driving. Can you tell? No. Clear? I did not know that drinking and driving is not allowed. No. Ignorance of Indian law is not allowed. Foreign law will be treated as mistake of fact. One person may know the law or both the persons may not know the law. Mistake of foreign law will be treated as mistake of fact. Any doubts? 2 minutes, I give you, just go through the from fraud till mistake. From fraud till mistake. What happened? Yes, there is one question which I've sent. We'll do that. Shall we do? First one. Kamala promises Ramesh to lend 5 lakh in lieu of consideration that Ramesh gets Kamala's marriage dissolved and he himself marries her. I didn't cover this topic still, but even then. Did you understand the question? Kamala promises Ramesh to lend 5 lakhs in lieu of consideration that Ramesh gets Kamala's marriage dissolved and he himself marries her. I will give you 5 lakhs. What you do, you marry my wife.
This is very uncultured.
Serious.
Is
Is it valid or void? That is the question. Is this agreement valid or void?
valid.
He will do like that.
No,
Void, no.
not daughter, wife.
Opposed to public policy, not daughter, wife.
Then no problem.
Next. Sohan agrees with Mohan to sell his black horse. Unknown to both the parties, the horse was dead at the time of agreement. Possible to perform? Void. Impossibility of performance. Ram sells the goodwill of his shop to Shyam for 4 lakhs and promises not to carry on such business forever and anywhere in India. He himself is willingly doing and tells that I will not carry. It is valid. In an agreement between Prakash and Girish, there is a condition that they will not institute legal proceedings against each other without consent. Agreement to restrain legal proceeding is void. You cannot stop a legal proceeding. But here, they are giving a consideration that without consent, we will not file a case against each other.
Valid.
Ramamurthy, who is a citizen of India, enters into an agreement with an alien friend.
Void.
Voidable? Void. I'll give you one more question. That question is incomplete.
Breakfast.
One question relating to this topic will finish and then we. You people got your breakfast too. AC off. Yes, Shrishti, a minor falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Gupta, owner of SP Laptops, the purchase of laptop on credit amounting to 60,000 for purchasing a laptop on 1st August. She promised to pay back the outstanding amount with interest at 16% per annum. by 31st July. She told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will pay back on her behalf. After 1 year, when Shrishti was asked to pay the outstanding amount with interest, she refused to pay the amount and told the owner that she is a minor. Now he can't recover a single penny from her. She will be an adult on 1st Jan 2024. Only after that the agreement can be ratified. Explain by which of the following way Mr. Gupta will succeed in recovering the outstanding amount. Case 1, by filing a case against Shrishti, a minor, for recovering the outstanding amount with interest. By filing a case against Mr. Ram, father of Shrishti, for recovering the outstanding amount. By filing a case against Shrishti, a minor, for recovery of outstanding amount after she attains majority. Case 1. Case 3, after attaining majority, no ratification. But this is covered under necessaries. Case 2 is also not covered because a parent cannot bind a parent for the acts he has done. So out of whatever assets and property minor is having, he will have to pay. A recent question only. 6 marks. How 6 marks will be given is all the 3 options you will have to give 1 to 3 lines. This is valid. This is not valid. This is not. That's all. We can take a break here.